listening to the Plugged In podcast, a new project from the Institute for Energy Research. To find out more about our work, visit our website at instituteforenergyresearch.org.
Welcome to the Plugged In podcast. I'm your host, Alex Stevens. I'm joined today by my colleague, Hunter Pearl, who recently published a blog on IER's website about a new plan from the Bureau of Land Management to reform the resource management plan for the greater sage grouse. Hunter, thank you for taking the time to talk to me today.
Great to be here.
So why don't you start by explaining to our audience why an energy think tank is concerned about the regulations surrounding a small bird out west?
Yeah, so this bird, it's got a bizarre courtship display, definitely something to look up, but it spans across 11 western states, so it has a big range, and particularly its courtship display involves it gathering in big areas, so the feeling is that it needs a lot of room on the prairies, basically the sagebrush steppes where it lives, and to that effect, there's been a lot of federal action to try to protect the sage grouse from development, which could potentially disrupt its displays and hurt its numbers. In 2005, the Fish and Wildlife Service studied it to see if it should be added, if the sage grouse should be added to the endangered or threatened species lists. It decided it was not threatened, and so that was the end of that for 5 years. Then in 2010, the Fish and Wildlife Service worried that the sage grouse habitat may be disrupted by development, and so they decided that in 5 years they would decide whether to add it to the endangered species list or not. And this is a huge deal. The endangered species list gives a lot of protections to animals to the point that it can really incentivize any kind of development working around these animals to really have to rethink whether the whole venture is worth it, because there are serious fines and they can be completely prevented from doing any kinds of development if endangered or threatened species are around. It was estimated that if this greater sage grouse was added to one of these lists, it would cost the economy of these states $5.6 billion per year. So a huge problem there.
So you have this long history of regulatory red tape all wrapped up into protecting these birds when, for one, it's not clear that they're really endangered this whole time, or that that their population is being threatened by development on federal lands. And you had the Obama administration stepping in to intervene. And so what sort of burden has that placed on people looking to develop land in these sagebrush focal areas that you're talking about?
It's exactly right. There's a huge swaths of land just unused for that reason. It's extremely burdensome to try to do any kind of development. There's a lot of potential mining activity that could be happening here, but you just can't when it's in an area that the bird might be in. And to say again, the bird is not endangered, not even threatened. Some recent studies have shown the sage grouse population increasing recently. The states have had plans in place for a while, and they have seemed to be doing quite well under them. In some states, there's enough of these birds that they allow hunting of them. But for the federal government, it doesn't look at, how is the sage grouse doing in this state or this state. It has one policy towards the sage grouse, which is they may be threatened, so give them the maximum protection. Don't allow any development that might offend the sage grouse in anywhere where it flies.
So your blog post that we're discussing here mostly goes over the Bureau of Land Management's revision to the management plan for these birds. Can you just give our listeners an idea of what changes they've proposed and what we can expect from the BLM?
The new revisions will limit the sagebrush focal areas, those most restrictive areas, to 1.8 million acres. So we're still we've cut down about 9 million acres there, but they've still got some area, and obviously all the state plans. And this will also give greater flexibility to the states to make their own conservation plans, to grant land use waivers. The idea being, again, these western states, they care about their animals, and they probably have much better knowledge of how to protect them than the federal government does. And so this is really going to be a win for the states. It's going to allow them to open up for development, but also to craft conservation plans that will actually work. The Endangered Species Act does not have a great history in terms of making these species recover. I think states will do a much better job.
So you also discussed some other news on the regulatory front. The Fish and Wildlife Service has also proposed revisions to the Endangered Species Act. And in your blog, you discuss how all these debates are tied into a broader discussion surrounding the power of executive agencies in terms of regulation. Can you explain where that debate is headed, both sort of in our public conversation, but specifically in the judiciary?
Yes. So the Endangered Species Act, it's getting revised just so that threatened species won't automatically be given all the restrictions that are applied to endangered species, and they're clarifying some standards for species listing and delisting and critical habitat designation. But there's a broader problem here, which is that the reason why, for instance, this revision is necessary is that agencies are given these very broad mandates. They're incentivized to read them as liberally as possible in terms of their own power to do things. So the case just recently came before the Supreme Court, Weyerhaeuser versus Fish and Wildlife Service. This concerned the Fish and Wildlife Service trying to designate an area in Louisiana as critical habitat for the dusky gopher frog. The problem is that frog does not live in that area. It has not lived in that area for 50 years, and it would not want to live in the area. The area is not optimal for the frog unless significant changes were made. Yet despite all of this, they labeled it a critical habitat, which meant that loggers in the area could not develop the land on the idea that somehow, if the land were different, it could potentially hold this frog. And so that came before the Supreme Court, and Justice Roberts specifically said that courts should be skeptical of agency claims of unreviewable discretion.
Basically what Justice Roberts is signaling here is that there's a possibility that we're going to open up that doctrine to possibility that it could be rolled back a little bit.
Exactly. This case seems basically a repudiation of our deference, or Seminole Rock deference, the sort of cousin of Chevron. Basically, Chevron says that an agency can interpret legislation, and the court is going to basically accept whatever the agency says is their mandate under the legislation. Our deference refers to the agency's interpretation of their own regulation. But in both cases, it's just the court is not really investigating whether the agency is correctly interpreting their statutes, whether they are in any way acting under the law. And Justice Roberts saying that the court should be skeptical of these agency claims didn't overturn it, but it seems the court is moving in that direction. And the recent justices, Gorsuch and Kavanaugh, have been explicitly critical of Chevron deference. So hopefully we will see some real change there for courts to be investigating agencies trying to expand their power.
So you conclude the blog post basically for a call to end Chevron and our deference. And obviously there's a defense of those doctrines that's put forward that basically says the people within the regulatory agencies have the expertise and are in a position to take a directive from a piece of legislation and administer it in the best way possible. How would you respond to that position?
If you think that the agency should be doing one action or another, just have that be in law. Have our representatives, the people that we actually elect and are democratically accountable, have them write into law that an agency should be, let's say, that on the question of whether the EPA can interpret any body of water as a navigable body of water. It's clear the EPA wants to interpret it that way. That would give them more power and prestige, but is that what we want for the nation? Well, how about we have our legislators determine that? The point of regulation is to have a regular set of rules and norms. If you want it to be regular, you need it to be predictable, accountable. Agencies are neither of those things. As we see, they interpret things differently depending on the administration. Just have it be in law. That way, it'll be checking the natural tendency of agencies to expand their power without any checks like a democratic system.
My guest today has been Hunter Pearl. You can read more about this topic at our website, instituteforenergyresearch.org. Hunter, thanks for joining me today.
Thank you.